Good afternoon, everyone, and welcome back. Well, today we're going to look at members' remedies and reporting and disclosure requirements. And before we proceed with today's lecture, we'll just try to recap what we have done so far in relation to directors' duties. Now, we've looked at various duties. We have looked at duty of care and diligence. We have looked at duty to exercise power for in good faith and for proper purpose. And last but not least, we have looked at duty to avoid conflict of interest. Now, all these duties, one of it might be coming out in your exams, which is worth 20 marks of the total exam paper. So, in relation to duty of care and diligence, how do we identify this duty? Now, when you have a question which relates to the business making any business decisions, that's when you are going to look at duty of care and diligence. You will look at it under common law, the law of negligence, as well as section 180 sub 1. And you have to talk about section 180 sub 2, which is the business judgment rule, and satisfy all the requirements related to it. Now, if the question indicates that there is a potential insolvency matter in relation to the decision made, then you would discuss section 588G to prevent duty to prevent insolvent trading, and defenses related to that, section 588H. Next, you look at section 181 sub 1 sub A, duty to exercise powers in good faith. So when the directors are given powers, they are expected to exercise those powers in good faith, and they have to act in the best interest of the company. And we have looked at it. When we say best interest of the company, it will be members as a whole, and when solvency decreases, then it would be duty owed towards the creditors. Then we looked at section 181 sub B, which talks about duty to exercise powers for proper purpose. And in the exams, if you are given a question in this area, then it would be in relation to issuance of shares. And you have to determine whether or not the issuance of shares has been issued for the purposes that it has been given, i.e. to raise capital. But if the powers are used to dilute shareholding, to defeat a takeover bid, or any other purposes than the legal purpose, then it will be deemed to be an improper purpose. And we have got two tests that you have to use. One is a single purpose test, which was decided in the case of Howard Smith and Ampol Petroleum, and the other one when you have multiple motives, which is the but-for test under Whitehouse and Carlton. So you would look at that. Next, we moved on duty to prevent conflict of interest. We looked at conflict of interest arising from improper use of position and improper use of information. Now, under conflict of interest, we looked at three potential areas. One, we looked at under general law, then we looked at under Constitution, and finally, we looked at under the Corporations Act 2001. Now, under the Corporations Act 2001, we looked at it under sections 182 and 183. And when we talk about conflict of interest, you have to also be wary whether we are discussing material personal interest. Although material personal interest has not been defined in the Act, but we know it has to be of substantive interest and not something trivial, and it must be personal in nature. Now, when a director has got a material personal interest, then the director has to disclose the interest. Under the general law, the director would be required to disclose in a general meeting, and if you follow the statute, depending on the type of company, if it's a proprietary company and the company has adopted the replaceable rules, then it will be section 191 and sections 194. Whereas if it is a public company, it is a section, and you will be looking at section 191 and 195. And further requirements of disclosure will be required if we are dealing with a related party transaction. Who is a related party has been defined under section 228, and what is the financial benefit has been defined under section 229. So according to section 208, a director in a public company who has got material or related party transaction and probably would stand to get financial benefit out of it needs to disclose this interest in a members' meeting, unless, of course, they fall under the exceptions that's provided under sections 210 right up to 216. All right, and we have looked at the common law cases like general law cases, like Aberdeen Railways and Blackie Brothers, Cook and Deeks, and we have also looked at Regal, Hastings, and Gulliver. So you're required to remember all of this, and if you get a question on conflict of interest, this is what you're going to look at. Last week when we finished, we looked at the case of Cook and Deeks, and Cook and Deeks is a case that I would like to highlight today because we are going to look at members' remedies. We had a situation where the directors who were also majority shareholders who have decided to transfer the contract belonging to the company to another company which they formed, and they actually convened a general meeting approving this particular transaction. Now the question is, what happens to the minority shareholder? Can he have access to any remedies? This is what we're going to look at today. Can the minority shareholder take an action? When the company is to receive a contract and that contract in inverted commas has been stolen from the company, who has the right to take the action? That will be some of the questions that we will be considering today. Now, upon completion of this topic, you would recognize situations of oppression of a minority shareholder or a member, understand when the courts would grant an order to wind up a company on just and equitable grounds under Section 461, understand personal rights of members as against the company and other members, understand the rules of force and harbottle. We will look at what were the rules that was introduced under the common law in the case of force and harbottle. We'll also look at the abolishment of the exceptions that was created under the rule of force and harbottle. We'll also understand what is meant by statutory derivative action and know a company's financial reporting and record-keeping obligations, including the reporting deadlines, and know the requirements of appointing and removing auditors. So what we're going to, in essence, look at is two areas. One is specifically members' remedies, and the other is reporting obligations of the company. So these are the two things that we're going to look at today. Now, as a member, if a member in a company is being affected by the actions of the director, we want to know whether the member has got any form of remedies. Now, in the exams, one of the best ways to find out whether you are dealing with a director's duty question or a member's question is to see whom you're advising. So when you go down to the question and it says advise so-and-so, for an instance, advise Fred on what he can do. Now, what I would suggest you do is replace the name Fred with his role. If you see that Fred is only a member and not a director, you will then put it on brackets on top of Fred's name, member. So now your question will be advise the member on what he can do. You immediately will have the clue that you have to answer the question in relation to members' remedies. Or if you write in brackets the name of the person as a director, then you know you're looking at director's duties question. So you have to be very, very careful because sometimes the facts of the situation may be highly similar to a director's duty question. And if you misinterpret the question, you'll probably be writing on areas which are not relevant to answering the question. All right, let's look at a hypothetical situation of TCC Limited. We now have Mr. D, who is also a shareholder, and he's got a shareholding of 25%. Mr. E is a shareholder, has a shareholding of 25%. F and G also have shareholdings of 25% each. So they have 1/4 of the shares of the company. Now the facts are Mr. D, E, and F are not in good terms with Mr. G. So D, E, and F formed a company called CPR Proprietary Limited and negotiated a contract and subsequently signed the contract on CPR's name instead of TCC Limited. Now, the hypothetical question is, if the directors, before commencing to proceed with the contract, decide to disclose their material personal interest in TCC Limited's directors meeting, which section will apply? if I'm deciding to disclose my material personal interest, what type of company are we dealing with here? Public company, very good. So we are dealing with TCC Limited, which is a public company. What are the sections? 191 first, and then 195. What does section 195 tell us? The directors concerned cannot attend the meeting and vote in the meeting concerning this matter. All right? Now, you need a quorum of 2 directors at all times. Here you have 3 directors with material personal interest, which means you would not be able to achieve the quorum. What need you do? Call for a members' meeting, because only 1 director would be insufficient for you to consider the matter. Okay. Okay. All right, under section 191 and 195, since it's a public company, there is a problem. There's no quorum, so we have to look at section 195 sub 4. 3 directors have material personal interest, so there cannot be 2 directors at all times to consider the matter. Now, what do? A general meeting needs to be called, and in this meeting, what will the majority shareholders do? Of course, ratify the transaction to divert the company's business. Now, you have to remember those 3 directors are also the majority shareholders of the company, aren't they? Because we have 4 shareholders, 3 of them have got material personal interest. Now, they will call the meeting and they will pass that contract resolution to ratify the contract. Correct? Right. So you have a problem, do you not? If the majority shareholders are also the directors and they are actually taking the opportunity of the company elsewhere and they're calling a meeting to ratify that contract, then a minority shareholder is being affected. So what are the wrongs done here? What is Mr. G considered as? Because he has 1/4 of the shares, he would be deemed as a minority shareholder. Has the actions of the majority members oppressed him? That's the next question we want to ask. Is it oppression on Mr. G? By bringing the business of the company elsewhere, would it be oppression? Yes, because you now cannot participate in the profits that is going to come out of that contract, and that could be deemed to be oppressive. All right? Next, what does oppression mean? All right, so that's what we're going to look at in terms of sections 232, 233, 234, and 235 of the Corporations Act. Next, another question. To whom was the wrong done? Was it done to Mr. G or was it done to the company? If I take away the business that belongs to the company, have I done a wrong to the company? Yes. So if I've done the wrong to the company, who can sue me? The company. Why? Because under section 124, we say that the company is a legal person and the company has the rights to bring action. But in our case, would the company sue? Why not? Very good. It won't sue. Why not? Will the directors initiate an action against themselves? Will they say, let's sue ourselves? They won't. So in this case, can Mr. G say, I will be the champion and sue on behalf of the company? That is the question we are trying to answer here. How many of you have done derivative finance? No. Okay. What does the English word derivative mean? What does it mean? Anyone? Derives from. Very good. Good word. Derive. What does derive mean? Comes from somewhere, right? Now, exactly. When we talk about derivative action, we are saying the power to sue is with the company, and this power now we are deriving from that power and allowing the member to take action. So the member is now filling the shoes of the company and suing on behalf of the company. This is derivative action. And the section that we will look at would be sections 236 and 237, where the member has to go to court and ask for permission from the court to bring this action. So that's the first step. They have to ask permission from the court to bring the action, and then they can initiate the action. So it's a two-step process. First step, ask permission. Next step, sue the concerned persons. All right? So we are now going to consider all the questions that we have raised earlier in relation to the subsequent slides. Now, although the directors have power to manage the company or the business of the company under Replaceable Rule 198A, members have power to amend the Constitution. And we know that because Section 136 sub 2 tells us that. What is the procedure that the members need to follow? If you're going to amend the Constitution, you have to pass a special resolution. All right? Once you have passed the special resolution to amend the Constitution, you will then lodge the amended Constitution with ASIC. All right? You've still got another test, which is the multiple choice question. You will be tested from topics 1 to 8. So you can't afford to forget that. Okay? Just not yet. Now, the will of the majority members through the general meeting will be deemed to prevail. And we also know Section 140 sub 1 tells us that it is a statutory contract, or the Constitution is a statutory contract between the member and the company, between the director and the company, between a member and another member. Now, minority shareholders will also be bound by this Constitution, and whatever rights that they have or arises as a result of being a member can be enforced by these minority shareholders. Now, members under a statutory contract can only enforce rights that arises as members. What are the cases that we looked at? Ali's case, Forbes, all right? Smolarek, okay. Now, a few remedies are available to members. Let's look at the remedies which are available. Remedies for oppressive conduct, winding up the company when it's just and equitable, seeking an injunction, Section 1324, enforcing members' personal rights, and members' statutory derivative action. Now, these are some of the remedies that is available to the members. Right, so those are the sections. Now, when we talk about enforcing members' personal right, it could be derived from express contracts, statutory contracts, or the statute per se. And when we talk about members' statutory derivative action, we are talking sections 236 to 237. Now, it's very easy to remember. All you need to do is, when you're talking about remedies under oppression, you start from 232 right up to 235. And then when you start on derivative action, you go on to 236 right up to 237. So it's sequential, right? Now, a member can seek remedy when it deals with oppressive conduct. What is oppressive conduct, or how do we define oppressive conduct? This is found in section 232. The courts may provide a remedy when the court finds that the conduct of the company's affairs or actual or proposed act by or on behalf of the company, or a resolution or a proposed resolution of members or a class of members, either is contrary to the interests of the members as a whole, or is oppressive to, unfairly prejudicial to, or unfairly discriminatory against a member or members, whether in that capacity or in any other capacity. Now, this is provided for under section 232. So if any actions that's proposed or has been resolved, which is contrary to the interests of the members as a whole, or it's unfairly oppressive, or unfairly prejudicial, or discriminatory, the word is unfairly discriminatory, then it will be deemed to be oppressive. Now, the word unfairly is very important because sometimes it could be discriminatory, but it is not unfair. One such situation, now we all had Commonwealth Games, right? There were so many countries participating in those games, and we had so many athletes participating. Now, what if every country decided to send all their athletes to the games? Does the organizer of the Commonwealth Game need to accept all of them? If they rejected them, can these members now say, I have been unfairly discriminated? Can they sue for an action? Why is it not unfair? It is discrimination, but is it unfair? If we accepted all these athletes, chances are we'll be running the Commonwealth Games for the next 10 years. Right? And that's not going to be in the best interest of the game. So in such a situation, the decision has been made that they would not accept more than a certain number of athletes. And although it's discriminatory, it is not unfairly discriminatory, and therefore it would not be considered to be oppressive. All right? So this is what you need to take into account. Now, a member can seek remedy from the courts if they deem that whatever actions that has been done in the company is oppressive towards them, or the affairs of the company has been done in an oppressive manner. Now, for you to find out what is meant by affairs of the company, you can look at section 53, which defines the affairs of the company. All right? And the person must be a member at the time the legal action is brought. And there are section 234 provides the list of people who can actually take actions for oppressive conduct. Now, in order for you to determine whether it's an oppressive conduct, the High Court of Australia has laid down the test in the case of Wade and New South Wales Rugby League Limited. In this case, as I explained to you on the situation of the Commonwealth Games, the facts are similar to that. What happened in this case is that the association was having a competition for rugby, and they had to actually stop one of those clubs from participating, called Western Suburbs Club. Now, Western Suburbs Club was not happy that they were stopped from participating, and therefore they brought an action for oppressive conduct. The question before the court was the refusal to allow them to participate in the competition was oppressive? Now, in order to determine oppressive, the courts used these tests. The question before the court was, what was the decision by the directors a decision that no board would acting reasonably would have made? So the question is, have this board of directors made a decision that any other reasonable board would not have made? If the answer is no, then it is not oppressive. If the answer is yes, then it will become oppressive. All right? Meaning to say, if the constitution of that particular society is to act in the best interest of the game, it is in the best interest of the game to have only limited participants so they can finish this tournament within a short period of time. And if they have too many people, then it's not going to be very effective. And that was the reason why they had to stop this club from participating. Now, would any other board have would decide the same way as this board would have? They would. So in this case, it is not oppressive. The intention of the directors when making the decision is not relevant. What is relevant is the effect of the decision. So we are going to look at only the effect of the decision to determine whether or not it is oppressive or not. Are we good? Okay, silence means acceptance. Now, although the board has discriminated against Western Suburbs Club, this was not unfair. The directors' actions were in the best interest of the game, and therefore it was not deemed to be oppressive. So when you're talking about section 232, after you've discussed the section, you have to talk about the test to determine oppressive, and you have to mention the case of Wade and New South Wales Rugby League Limited. Now, these are some of the examples that I want you to keep in mind, because if you have a question on members' remedies and they're going to ask you in certain situations, these are some of the examples that you will look for. One of the most familiar ones would be diversion of business opportunities, where the opportunities of the company is brought to their own company or to someone else. Now, if you have this situation, if you're advising a member, it would be an issue of members' remedies, and you are looking at oppressive conduct. Now, what case under the director's duty can you remember in relation to diversion of business opportunities? Diversion of business opportunities under director's duties? Sorry? Can't hear you. Regal Hastings, was it diversion of business opportunities belonging to the company? They made use of an opportunity in their position, but they did not divert any business opportunities. The case is Cook and Deeks. Now, Cook and Deeks is a very, very popular case both for conflict of interest and members' remedies. So you probably would put it in mind or keep it in mind, right? Improper exclusion from management. Sometimes you are a member of the company and you're also director of the company, and where the other majority directors or shareholders as well have removed you from managing the company. So you have been improperly excluded from management. Unfairly restricting dividends. This is a situation where the company is making lots of money. Instead of declaring a dividend, the directors have decided that they will get fat bonuses, and they've bought company cars and started driving them, and they're enjoying themselves. And here the members are not getting any dividends. So this would be unfairly restricting dividends. However, if the company adopts a policy, a financial policy, which is very moderate, they are very careful, all right, and they're not into splurging. Now, if such be the situation and they have deliberate policies to pay lower dividends, that cannot be considered as oppressive. The case of Thomas and H.W. Thomas Limited was related to a company where one of the members told the company directors that the assets should be sold and reinvested into a different business where they could get higher profits, and this could then escalate into greater dividends. Now, it was a risky business. The other members did not favor this. They didn't want this to happen, and therefore they were not in agreement. So in this case, when the member who did not get his will approved by the directors brought an action for oppressive conduct, and the court said in this case it is not oppressive conduct, because you can also look at the other members were not favorable to have this kind of business dealing. Next, you will look at oppressive conduct of board meetings, where they come to the board, they do not give you the relevant materials, do not give you time to table their views. These type of conduct would be also considered as oppressive. Issuing shares to reduce members' ownership interest in the company. This was in Kokoto Witch Construction Proprietary Limited and Wallington. There were two parties who formed a company, and they were also shareholders of the company. And subsequently, they fell apart. Obviously, that happens. And when that happens, one of the party decided to issue more shares to dilute the other party's shares. And this was deemed to be oppressive as well. So these are some of the scenarios when it was considered as oppressive conduct. And when it's oppressive conduct, you have to keep in mind two types of action. First, is it oppressive to the member personally? If it is oppressive to the member personally, he is going to bring a personal action, and if he's successful, he is going to get compensation in his personal capacity. Because when we look at another remedy, i.e. derivative action, the member is bringing an action on behalf of the company, and whatever compensation that is received will be the company's property and not the members. So these two remedies, you'd see, one is at the personal capacity of the member, the other is on behalf of the company. Now, in a question in the exams for members' remedies, which is a good question for you to have in the exams, you just need to ensure you discuss the personal remedy under sections 232 up to 235, and you discuss derivative action under 236 and 237. And you'll be able to do very well in this particular question. Now, section 233 states orders that the courts can make. They can actually order for a company winding up. They can say that the company's existing constitution be modified or repealed. So if the majority shareholders have changed the constitution, the courts can order it for it to be rechanged. Regulating the conduct of the company's affairs in the future, the court can say, look, we want all these 3 directors to be removed and replaced, for an instance. That's how the court is regulating the conduct of the company's affairs. For the purchase of shares with an appropriate reduction of the company's share capital, this is share buyback, and for the company to institute or defend proceedings. So here, the court can say one of the members can take an action on behalf of the company, and sometimes it could be a situation where there is an appointment of a receiver. A receiver is a person who is appointed to the company, who takes hold of a property, and he sells the property, realizes the cash, and pays the relevant creditor. Now, a receiver and a manager is a person who can take hold of that property and manage the property. So these are the type of administration that you can have in relation to receivership. Now, when we talk about winding up, normally the company would be insolvent. That's when we go for winding up. But then, in this situation, the company is not insolvent. This company is still solvent. However, the member wants to wind up the company. Now, in the process of the members winding up, if they discover that the company is insolvent, it will automatically convert itself into a creditor's winding up. All right? For this winding up to happen, the company has to be solvent, which means it is able to pay its creditors. Now, member can apply to the court to compulsorily wind up a company if it can be proven that the directors have acted in their own interest and not for the members as a whole, or appears to be unfair or unjust to members. And this is provided under section 461 sub 1 sub E. Or acts or omissions are oppressive or unfairly prejudicial, section 461 sub 1 sub F. It is just and equitable for the company to be wound up. Now, in the exams, you probably make one statement in relation to winding up for just and equitable reason and mention section 461 for you to secure the 1 mark that's out there. All right, if you have a question on members' remedies, that's just 1 mark. So just remember that you don't need to bother about the subsections whatsoever. Section 461 sub 1 would do the deed. All right, now breakdown in mutual trust. You can look at the case of Ebrahimi and Western Galleries Limited. Now, when you want to apply for a winding up on the grounds of just and equitable reasons, one of the reasons is where there is a breakdown in mutual trust. Now, what happened in this case where there were 2 parties who were partners, and later they incorporated a company and they became the directors of the company. And this was a company which was dealing with carpets, the sale and purchase of carpets. And when the profits were made, what the directors did was that they shared the profits equally as directors' remuneration and never paid any dividends to the members because they were the directors, they were the members. Subsequently, one of the party's son was also appointed as a director, and there was a fallout between the members. So the father and the son decided to remove the person from being a director. As a result of which, he was now not able to participate in the profits of the company. Now, they started off in mutual trust, but later on, obviously, there's a breakdown in the trust. All right? And therefore, when the party brought an action in court, the court said, yes, since there is a mutual breakdown in trust because of their relationship, the court said this company can be wound up on just and equitable reasons. Good? Right. The next type of remedy we look at is statutory injunctions. Now, injunctions are just a legal term for a simple layman word called stop order, right? You want to stop someone from doing something. That's an injunction. Now, a member can apply for injunction under sections 1324 to stop or refrain a party from doing a particular action in breach of the Corporations Act. Now, when we look at directors' duties being breached, is that a breach of the Corporations Act? Section 180, 181, 182, 183? When the directors behave in a way that is not acceptable, is that a breach of the Corporations Act? Yes. Now, you can, as a member, apply for an injunction to stop them from continually breach their obligations. Members have no right to inspect the books unless directors grant permission under Replaceable Rules Section 247D. Now, most of you will not pay attention and will not put this on your cheat sheet. Believe me, you get 3 marks in a question like that. All right? So make sure this is in your cheat sheet, however insignificant it looks. All right? The general rule here is that members do not have any statutory rights to inspect any books unless the company has adopted the replaceable rules, which is Replaceable Rule 247D. Here, the directors can grant permission or a members' meeting can be convened to grant that permission. Otherwise, what the member can do is that apply to court to get an order to allow him to inspect the books of the company, but the courts will not grant it if the courts believe that the person applying for it is not acting in good faith and for a proper purpose. You can't be applying for it to witch hunt, all right? That would not be a proper purpose. You seriously want to know, and the reason is because the directors are not disclosing and you have an interest to know, then you can apply, and that is Section 247A. You mention these 2 sections and you mention the principles. If it comes out, 3 marks. But it has come out, so that's the reason why I'm telling you, right? Members' personal action against members' derivative action. Now, a member has a personal action to enforce a statutory contract. Your personal action can arise as per a contract. If a member has signed a shareholders' contract, now whatever rights that arises from the shareholders' contract will be a personal remedy or a personal right that the member has. The other is under statutory contract. As a member, you have got rights that arises out of your statutory contract, and we know that because Section 140 tells us that. Where an action of the directors or members affect a personal right of a member, right to vote, the member can enforce the right. So if the member is stopped from voting in a meeting, obviously the member can enforce that right. And instead of commencing a personal action, a member may also be able to take derivative action, i.e. an action belonging to the company. Now, again, this could come out as a part question, which is worth 3 marks. So when you have a members' remedies question, if it is going to be an essay-based question, part of the essay will be this, 3 marks, and then the remaining would be a problem question related to members. So here they will ask you what is the rule under Force and Harbottle. You have to only remember 2. One is the proper plaintiff rule. If a wrong is done to the company, then the proper plaintiff is the company. All right? The second is the internal management rule. The courts do not want to interfere in the internal management of the company. So the court wants to leave whatever problems that is within the company to be dealt by the company, because they have got an effective board of directors who can make decisions. And they also have got members in a general meeting. So this can be done by the company themselves effectively, and there is no need for interference by the court. However, under the general law, there were some exceptions recognized under Force and Harbottle, but it kind of transferred the risk and the cost to the members, and therefore this has been abolished today, and we have only access to statutory derivative action. So we don't look at any of the exceptions under Force and Harbottle for the purposes of the Australian company law. Now, if you were in the UK, that would be different. Then you'd still look at the exceptions under Force and Harbottle. The effect of the rules in Force and Harbottle was said to greatly disadvantage minority shareholders, as a result of which it has been abolished. Section 236 sub 3. All right? Now, the reason why derivative action has been introduced is simply because we know when the majority shareholders are also the directors, chances of them being held liable for whatever the offenses that they have made would be highly unlikely, and therefore we need to allow somebody else who could bring the action on behalf of the company. So here, Section 236 tells us who are the people who can initiate this action. It could be past or present member, officer. All of these people can bring an action. However, they need the leave of court. The leave of court is just a legal term for permission of court. So the word leave means permission. Now, Section 237 gives you the criteria that needs to be satisfied. So let's look each of the criteria. Now, this is the conjunctive criteria, which means you have to prove all of it. Failure to prove any of it would mean you cannot bring, or you would not be given an order to bring derivative action. The first criteria is it can be proven that there will be inaction by the company, i.e. the wrongdoer would not bring an action. All right? So it can be proven that the company will not take an action on this matter. Sub B, 237 sub 2 sub B tells us that the applicant must act in good faith. He does not have any hidden agendas. 237 sub 2 sub C, it is in the best interest of the company that the applicant be granted this leave to bring this action. Now, when we talk about in the best interest of the company, what the courts are trying to do is that trying to find out whether there was any valid reasons why the company has not taken any action. Sometimes, if the breach by the directors or majority shareholders only cost the company about $5,000, would you want to take an action worth about $50,000 chasing the $5,000? Probably not. So there is some reason for the company not taking any action. So in this case, they want to decide whether or not there is any such reason. And that's the reason why they're requiring that it should be in the best interest of the company. Next, we are looking at Section 237 sub 2 sub D. There must be a serious matter to be tried. So there is an issue to be considered by the courts. And last but not least, a notice has been served to the company of this intention to bring this legal action, or where notice is not given, but the court deems that it is appropriate to award or to allow this order, the courts will do so. All right? So if you have proven all of this, then you will get the permission of the court to bring an action on behalf of the company. So on your facts, the first thing you have to do once you have discussed the law is that you have to now say on the facts, the chances of this company bringing an action would be highly unlikely because the majority shareholders are also the directors of the company. They are not going to initiate an action on themselves. Therefore, this element of inaction by the company can be satisfied. Then you look at the next element. On the facts, there is no evidence to suggest that the member has got any bad faith in relation to this transaction or this application. Following that, is it in the best interest? You can assume that it is in the best interest of the company and there is a serious matter to be tried, and you can also assume that notices have been served. Having satisfied this, the chances are the courts will give the permission to this particular member to bring a derivative action. However, please remember, when you bring an action, you have to pay out of your pocket. Now, if you are a member, would you take an action against or on behalf of the company, and would you also take a personal action? You have only limited money to bring legal action. Which action would you pursue? On behalf of yourself or on behalf of the company? Self comes first, right? Now, a good student would mention that. Would say, yes, there's two possibilities. However, the chances are there's a limitation in terms of resources. Therefore, the member would be advised to take up an action personally, because then whatever benefits that arises from there will belong to the member. All right? Now, if you go to court, obviously the wrongdoers will come there to try to prove that these elements cannot be satisfied. In that case, the court will consider whether members' ratification in granting leave. And ratification does not preclude any application under Section 237. What are the court's powers? What powers do they have? They have power to make cost orders and make the company pay for the legal costs of the applicant. Action cannot be settled out of court without court's permission. So once an action under derivative action has been started, you cannot have out-of-court settlement. Section 241, to make any order including an appointment of an independent person to investigate the company's affairs, and company's annual report is to state the details of the actions that is taken by this particular member. All right? So basically, you have looked at members' remedies. All you have to remember is that the member has got personal remedy under statute as well as under general law. Under statute, you can look at sections 232 right up to 235. When the conduct of the directors or the majority shareholders are oppressive towards the member has got a personal action and he can sue under sections 232 to get compensation. All right? The other way, normal situation when an oppressive conduct action is taken is that the courts will then ask the company to purchase the shares belonging to the minority shareholders at a reasonable price because they have acted oppressively. Next, we look at in terms of general law. Under general law, we can see whether there is a contract. If there is a contract, then the member would have some personal rights that he can enforce. We can also look at the statutory contract, which gives the member personal rights to be enforced. And the next thing we look at is derivative action, where the member is suing on behalf of the company. Section 236 to 237. Now, in a question for members' remedies, these are the two main areas that you need to discuss. You will discuss statutory injunction 1324, 1 mark, and you will discuss also winding up on just and equitable reasons, another mark, section 461. All right? So if we've discussed all of this, you pretty much secure full marks. And then how you apply will depend on you. Okay? Now let's look at reporting and disclosure. These can come out as an 8-mark question, and a lot of times it's a very straightforward copy and paste sort of question, meaning to say you have to recopy it into your answer booklet. Basically, make sure you have it written in your cheat sheet. If it comes out, it's like a bonus. write everything there and you get your 8 marks. But make sure your cheat sheet is not verbatim. You have reworded it in your own words, and when you rewrite it, it's your own words that you're rewriting to get the full marks. All right? Now, the purpose of disclosure obligations is to protect investors and to make sure that investors can be confident that the information is accurate when making a decision. And this is very, very relevant, especially when we are dealing with public companies who have got access to the public in relation to the investments. It could be public companies which are listed as well as unlisted public companies. Clerk 9 introduced reforms relating to auditor independence, directors' remuneration, directors' disclosure, and continuous disclosure. Now, all companies must keep financial records, all right? That is a requirement under the law, and all companies must keep. It doesn't matter whether you're a proprietary company or not, you must keep financial records. Now, what are financial records? Minutes book, members meeting minutes and resolution, register of company, all these are considered as records. All right? And Section 9 defines financial records. Section 286 sub 2 says all the documents must be retained for a period of 7 years. That is a legal requirement. Most legal documents are retained for a period of 7 years. Section 251A, all members and directors' meetings must be recorded in a minutes book within 1 month. Why do we record all these minutes in the minutes book? Sorry? For the auditor. Why need we keep it for the auditors? Sorry? Cite as an evidence. Yes, it is evidence that the decision has been taken. Most of us, how many of you remember what you ate last night? Oh, at least one person can. Most of us would have to scratch hard to think what we ate last night. What more if you are going to a directors' meeting and you have agreed to many resolutions, can you remember all of them? Chances are you can't. So you need to document them in order for you to recall what has been agreed in the meeting. And when an auditor comes to audit the company, he needs to know why was this action carried out? Was there any resolutions approving this action? So what do? They pick up the minutes book and they check and counter-check the actions. Has this been approved before? If it has not been approved before, then the auditor flags it out, because he says this has not been approved. We do not have any evidence suggesting that it has been approved and the company has acted in a way that is not right. So this is why it's important. It becomes evidential. Next, we look at members are entitled to inspect the minutes book that is provided under Section 251B. And you all remember the facts of ASIC and Helicare? This is where a media release was released saying that there was sufficient money in the asbestos funds claim, when in fact there was none. But the director said, oh, we didn't know about that. But the courts actually referred to the minutes that was passed, where all of them agreed to the announcement. So they said, look, this is evidential that you have agreed to it. Too bad. All right? Then Section 172, companies must keep registers at the company's registered office, and companies must keep a members register. Why do we want to keep a members register? Now, if you're a small company, you want to know movement of your members, who has gone, who is still a member, so you need to know that in order for you to send notices of meetings. If you do not know who your current members are, how would you send notices to them? Now, in a public listed company, you can't handwrite all your members because you may have thousands and thousands of members. You will have a members or shares registrar. The registrar will keep in tag of all your members. So when you want to send out circulars or notices, you will call your shares registrar, who will then print out all the members that you have and send it to you for you to then send all the notices. All right? Section 176 provides that the detail in a register can be taken as truth and can be legally relied upon. And Section 175 sub 1, company can apply to court to make corrections to the register. Now, I've not seen any past year questions in this area, but I don't dare say it would not be examined. Okay? Now, information to be lodged with ASIC and ASX, annual review of companies. Now, annual review of companies will be issued by ASIC, who would extract the particulars of the company and together with an invoice, send it to the company. All right, so every year at the anniversary of the incorporation, ASIC will extract all the information that they have and they will attach their invoice and send it to the company. Now, the company's job is to check whether all the information that has been extracted is correct. If it's not correct, then they have to resubmit to ASIC with the corrections included within 28 days. So they need to notify ASIC within 28 days. Section 347A, directors will have to pass a solvency resolution if company has not lodged accounts in the 12 months leading up to the review, i.e. where the anniversary of incorporation has come about, but then no accounts have been lodged with ASIC, then they have to pass a solvency resolution. Now, if the company is insolvent, ASIC must be notified within 7 days. ASIC regulations requires companies to notify ASIC on changes to its registered office, directors, using appropriate forms. So there are forms that you have to fill up that you can find under the ASIC website, and you have to keep your information updated because ASIC is the custodian of information, and whatever information that comes out of ASIC or when a search is done is deemed correct. So for that purposes, the companies have a duty to ensure that they are constantly updating all their information. ASX listing rules require listed companies to lodge financial information on ASX, including continuous disclosure of material information. So the directors of the company would be required to make continuous disclosure. If the company is going to make an investment somewhere, which has an impact on the share price, for an instance, this would require disclosure. So there are some disclosure requirements that a listed vehicle or a listed company or listed issuer needs to comply with. Next, we look at the annual financial reports. Let's look at section 285. Right, this is the annual financial reporting. If you see, preparation of financial report under section 295, the financial report includes financial statements, disclosures and notes, and director's declaration. Preparation of director's report under section 298, unless the report relates to a company limited by guarantee, it has a general component, a specific component under section 300, and a special component for listed companies under section 300A. You can look at section 285A for an overview of the obligations of companies limited by guarantee, but you're not going to be asked in specific in relation to companies limited by guarantee. Next, have the financial report audited and obtain auditor's reports. You can look at sections 301, 307, and 308. A small proprietary company prepares a financial report in response to a shareholder direction under section 293 only, has to have an audit if the direction asks for it. Normally, a small proprietary company does not require audited accounts. Now, there are similar rules for companies limited by guarantee. We are not going to look at that. Section 312, officers must assist the auditor in the conduct of the audit, and ASIC may use its exemption powers under section 340 and 341 to relieve large proprietary companies from audit requirements. How do we classify a large and small proprietary company? Which section? Section 45A. What is the requirement? You need to satisfy 2 out of the 3 requirements. What are they? Sorry? Consolidated revenue of 25 million, gross assets of 12.5 million, and less than 50 full-time employees. If you can prove less than 2 of these requirements, it will be a small proprietary company. If you can prove more than this 2 requirements, it will be a large proprietary company. Don't forget, you have got your multiple choice questions coming up. All right? Lodge the financial report, director's report, and auditor's report with ASIC, section 319. And for public companies only, lay financial report, director's report, and auditor's report before an AGM, section 317. So that is an overview in relation to the reporting requirements. Section 292. All right, financial report and director's report must be prepared by disclosing entities, i.e. listed companies, public companies, and large proprietary companies. And under section 292 sub 2, small proprietary company does not have to prepare financial and director's report unless it is directed to do so under section 293 and 294. And under section 292 sub 2 sub B, it is foreign controlled. Then it is required to do so. Otherwise, it is not required to prepare any financial report and director's report. Section 302, disclosing entities must prepare half-yearly reports. So this is your reporting deadline. When we talk about disclosing entities, we're talking about public companies listed on the stock exchange. So the deadline for reporting is the earlier of 21 days before AGM or 4 months after financial year end. And deadline for lodgement with ASIC and ASX if listed, annual report 3 months after year end, and half-yearly report 75 days after half-year end. If you can see there, only a disclosing entity needs to submit a half-yearly report 75 days after half-year end. Then you have a public company, which is not a disclosing entity. The requirements for deadline for reporting to members would be similar to disclosing entity, 21 days before AGM or 4 months after year end, and for lodgement with ASIC is 4 months after year end. Small proprietary company, the later of 2 months after the date of the request and 4 months after year end, and there is no requirement for them to lodge with ASIC. Large proprietary company, 4 months after financial year end, and they have to also lodge with ASIC 4 months after financial year end. Please have this in your cheat sheet because you may get a question on reporting deadlines. It's pretty straightforward. If you can write this, you may get an 8 marks answer, almost 8 marks. You may get 7, 6 marks, 7.5, depending on how you write. Okay? Disclosing entities, reporting, and continuous disclosure. Section 302, disclosing entities must prepare half-yearly reports. 320, disclosing entities to lodge half-yearly reports 75 days after half-year end. And ASX listing rule also requires disclosing entities to send half-yearly reports to ASX. And continuous disclosure obligation to ASX of market-sensitive information. And section 677 sets out the test for determining whether the information is market-sensitive. What is financial report? You can find that under section 295. you need to have the following: financial statements, disclosures and notes, and director's declaration. All right? Financial statements are defined as profit and loss statement, balance sheet, cash flow, consolidated profit and loss. You are all accounting students. I think you are very well familiarized with this. All right? And what is the accounting standards that you use? You don't even know your accounting standards. That's a relief. Okay. Now, director's report. The contents of a director's report is found under section 299, review of operations, major changes in the state of affairs and activities, and circumstances that may affect future operation. Now, to actually have a look or to have an understanding how a director's report looks like, you can go onto ASX website and you can download any of the annual report, and you will see how a director's report has been tabled in the annual report. All right, so basically it will contain all of this information. Audit report, section 301. All companies that need to prepare financial statements are required to have them audited. Small proprietary company does not require their financial statements to be audited. Section 307, auditor to form an opinion whether financial reports complies with the accounting standards and shows true and fair. What is a qualified report? If you were to become an auditor and you have signed off a qualified report, what does that mean? That means you have some reservations in relation to the company's dealings. You do not sign off completely. You are actually stating your reservations, meaning to say you're protecting yourself from being sued in the future. All right? So that would actually have a red flag for ASIC to pick it up, because they would ask, why is the auditor having reservations? Now, if audit report is qualified, the auditor must state the reason. An audit report on half-year accounts, auditor's power to obtain information, and contravention of the law is to be reported to ASIC. Now, this has also been tested in the exams before. Auditor's qualification. All right, so section 324AA, company may appoint an individual company or firm as its auditor. Individual must be a registered auditor, appropriately qualified and professional training. Auditor must be independent with no conflict of interest. Now, normally a 3 marks question may sound insignificant to you, but it could make a difference to your results. It could be a high distinction and a distinction, could be a credit and a distinction. I'm not going below that. All right? Now, appointment and removal to provide members with independent view of the company's financial position, and appointment of public companies auditors are generally appointed by the directors, but confirmed at the next AGM. Proprietary company, they are appointed by members. Only registered auditors can be appointed, meaning to say you have to register yourself with ASIC, and only then you can be appointed. Auditors' independence were introduced in CLERP. At least 2 months' notice is required for when the auditor is to be removed, and auditors can resign by serving notice. Now, once they want to remove an auditor, this has to be reported to ASIC, and ASIC's consent should be obtained when you are planning to remove an auditor. You can't just remove an auditor as and when you feel like it. All right? Auditors are terminated by appointment of a liquidator. Auditors' duties, they are to provide independent view of the company's financial position. They are to form opinion whether the financial report complies with the accounting standards and shows true and fair view, and they have a contractual relationship with the company. And in this case of Ascenda Finance Corporation Limited and Pete Marwick and Hungerfords, what happened in this case was that audited report was made up for the company. However, a third party looked at the audited reports and decided to provide finances based on the audited reports. And later on, they discovered that the audited reports were not accurate, and they decided to sue the auditors for preparing a flawed audited reports. Now, the court said, Here, the third party did not have any relationship with the auditor, and the auditor did not know that this third party will rely on the audited reports to actually give finance to the company. So therefore, the auditor in this case was not responsible for the losses suffered by the company. All right? That's the case of Ascender Finance Corporation Limited and Pete Marwick. So in a nutshell, you need to know members' remedies, in particularly oppression remedy and statutory derivative action, and financial record keeping. Some parts of it that has been mentioned, please put it onto a cheat sheet. It's pretty standard. If it comes out, you can just write it and get marks. Audit requirements and continuous disclosure obligations. I'll see you all next week. Have a good weekend.